Hello, everybody. Welcome to the Fearless Floyd Show. As always, I am your host, Fearless Floyd, and today is Sunday, Father's Day, June 18th, 2023. So, for all you fathers out there who didn't see my previous video, happy Father's Day to you. Even if you're not a man, you still had to be a father to your kid, no matter what that looks like. So, happy Father's Day to all you out there in the world. And of course, here we are today. I'm doing part three, Bonnie straight facts. So today we're going to dive into one of her, as I've been digging, kids. As I've been digging, folks. Man, this woman, don't be surprised if they hit her with the vexatious litigant here pretty soon. Okay. I can see the writing on, I'll just put it that way. She is prolific in the courts, especially in the appellate courts. So I'm finding more and more. But what's good about reading these records is you get to digest some fun facts about, what's transpired in this whole scheme of things. You know, how much of it is actual accurate, 100%. You have to take that with a grain of salt, look at the source. It's coming from a trial record. So, it is a public record, but it is what it is. It is the record, as we so say. But before we do that, let me all right. Yeah. Hmm. Hang on. Yay. Here we go. All righty, guys. There she is. Y'all want to write Bonnie? There's all her information. So if y'all want to write her, go get a pen, write that down. I'll tell y'all what, I'm gonna fix it so y'all guys can get it. Now that you don't have a pen, and you know, just look at that. See how good I am. Bonnie, there's a TDCJ number, unit, address, Marlin, Texas. If you want to call, because your media, some type of religious council, whatever that looks like. Even if you're a potential employer, I don't even think she has to know that you're going to be a potential employer. Call that number, set up a visitation schedule, and go see Bonnie. There you go. Or you can write her. There you go. Can't send cards. They outlawed cards, so don't send her cards. But you can send her some commissary money, some necessary commissary you can get down for old Bonnie. Bless her game. Apparently, according to the public trial records, she's indigent. She's broke. She don't have any money. So I don't know what her and David been doing for the past 2.5 years. I guess they just, I guess they're giving everything to charity. They're just like in one hand out the other. I don't know. Maybe y'all can answer that question. I don't know. All I know is what I read. That's what I'm reading. And you know what they say? Smells like a fish. Probably a fish. What? Oh, this is a federal one. Hmm. Yeah, this thing's a book here. Um, and this out in the Northern District of Texas, where Bonnie wanted to sue God and everybody. Right. So let me get over here. Uh, so we're going to go over this one because this one has a lot of intricate information for you guys right here. 10th Court of Appeals, there's your number. 10 stands for the court. That's the year. And then that's 138th case filed in 10th Court of Appeals. CR, criminal. That was a CV, it'd be civil. That's how you read that. I. So when you want to watch it, it closes over to another tab and it opens up a little bit bigger. But I told y'all because of that Zoom tweak, I am going to open up the proper one just to start with. Focus. All right, here we go. There's your 1017 138 CR. Bonnie Allen Thomas, not to be confused with Thomas, Bonnie Allen. Okay, she's the appellant. It's from the 18th Court in Johnson County. There's that F5926 again. Memorandum opinion. Appellant Bobby Allen Thomas was convicted of carrying a weapon in a prohibited place and sentenced to 5 years probation. Thomas challenges her conviction in 5 issues. We will affirm. That means they affirm the lower court's verdict of guilt. If they address the punishment, I don't know, but I don't think so. So just the guilt and innocence phase, the facts of the case. Background. The underlying facts are not in dispute. So apparently nobody's disputing the facts. Thomas appeared before the 18th Judicial District Court Judge, John E. Neal. And there's a footnote. So at the bottom of this particular page, there'll be what that footnote references in a family law matter. Okay, I'll just tell you anyway. He, by the time this got to the 10th Circuit or 10th Court of Appeals, he was no longer a family court judge. He was on an appellate court of appeals justice. So he had to recuse himself because he was party to another legal matter for Bonnie Allen Thomas. Now, after a status hearing, Judge Neal verbally ordered Thomas and her ex-husband to surrender their firearms to their respective attorneys. Thomas informed the trial court that she owned and or possessed only one firearm. Thomas surrendered that weapon to her attorney, who filed an affidavit acknowledging the same with the trial court on August 31st, 2015. Thomas subsequently told her lawyer that she was in possession of another firearm. On October 21st, 2015, Thomas entered the Gwynn Justice Center carrying the firearm inside her purse. Thomas went through security screening and walked toward the elevators before being stopped by security officers who asked her to return to the screening area. The officer escorting Thomas back to the security station told Thomas that he needed to search her purse. As the officer reached for Thomas's purse, she ran through the metal detector and out the front doors. One of the security officers detained Thomas as she reached the bottom of the front steps. The security officers then recovered a .22 caliber revolver from Thomas's purse. Thomas was placed under arrest. Issues presented by the appellant, Thomas. Thomas presents the following issues. There's a footnote number 2. So right here, here's footnote number 1 addressing Judge Neal, Justice Neal now. Although initially assigned to Thomas's criminal case, Judge Neal recused himself. Judge Neal was appointed and sworn in as a justice to the 10th Court of Appeals on February 20th, 2019, obviously several years after. Justice Neal recused himself from this matter on April 5th, 2019. Gentleman did the right thing. All right, so these are her issues, and 5 of them are being presented. Testimony by the recused trial judge created prejudicial error. The state failed to establish recklessness because the alleged underlying order was void and not properly proved. The state failed to establish a violation of Section 4903A3 of the Texas Penal Code as worded. Section 46.03A3 of the Texas Penal Code is unconstitutionally void for vagueness. Section 4603A3 of the Texas Penal Code as applied violates the separation of powers clause in the Texas Constitution. Discussion. Constitutionality of Section 46.03 of the Texas Penal Code. We begin with Thomas's first three issues that relate to the constitutionality and application of Section 46.03 of the Texas Penal Code. In her fourth issue, Thomas asserts that Section 4603 is unconstitutionally vague. Thomas asserts in her fifth issue that an edict by the sitting judges of Johnson County that applied the Section 4603 to the Gwynn Justice Center violated the separation of powers clause of the Texas Constitution. In her third issue, Thomas argues that the state failed to establish a violation of Section 46.03 because the language of the statute does not apply to the entryway to the Gwynn Justice Center, and that the attempt by the sitting judges to change the definition of premises is void and invalid. Section 46.03 provides in pertinent part, quote, a person commits an offense if the person intentionally, knowingly, or recklessly possesses or goes with a firearm on the premises of any government court or offices utilized by the court, unless pursuant to written regulations or written authorization of the court, close quote. Id at Section 46.03A2. Section 46.035F3 defines premises as, quote, a building or a portion of a building. The term does not include any public or private driveway, street, sidewalk, or walkway, parking lot, parking garage, or other parking area, close quote. It at Section 46.035F3. When the constitutionality of a statute is attacked, the reviewing court commences with the presumption that the statute is valid and that the legislature did not act unreasonably or arbitrarily in enacting the statute. Peraza versus State. These are all some, that's a new case backing up an old case. The burden is on the party challenging a statute to establish its unconstitutionality. It's very difficult. We must seek to interpret a statute that such its constitutionality is supported and upheld. If a statute is capable of two constructions, one of which sustains its validity, the courts will give to it the interpretation that sustains its validity. I'm not reading the case sightings. A facial challenge is an attack on a statute. A facial challenge is an attack on a statute itself as opposed to a particular application. We have articulated how we review a facial challenge. To prevail on a facial challenge to a statute, a party must establish that statute always operates unconstitutionally in all possible circumstances. See, that's the hurdle you have to get over. That's the first hurdle. All right. And you can see that's a very tall hurdle. A facial challenge to a statute is the most difficult challenge to mount successfully because the challenger must establish that no set of circumstances exist under which the statute will be valid. I mean, yeah, sorry. I didn't want to say anything before I read this because I haven't read this. It's the first time I've read it. But when I just skimmed over the issues, I was like, oh, I did an eye roll. They took her money. Surprise! Right? Whether a statute is facially unconstitutional is a question of law that we review de novo or anew, okay, at the beginning. All right, there's that Garon versus State. I've used that plenty of times. The party facially challenging a statute must establish that the statute could never be constitutionally applied to any defendant under any set of circumstances. See what I'm saying? It's like very difficult. The vagueness issue. Thomas first asserts that 46.03 is unconstitutionally vague. Assuming without deciding that Thomas has preserved both an actual and facial constitutional claim, we find that the statute passes constitutional muster. Thomas specifically argues that the definition of premises is insufficient to provide notice of what the statute prohibits. The statute is unconstitutionally vague if its prohibitions are not clearly defined. A reviewing court should use the following analysis in construing the meaning of a Texas statute. And I've read this before. I really don't want to get into the minutia of all this, but let's just say boom, 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 because there's a lot to go through here. As noted, defines premises as a building or a portion of a building. The term does not include any blah, 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 blah. I read that. The Texarkana court has noted that the plain meaning of the phrase building or a portion of a building is clear and unambiguous. So they're going to a sister court, parallel court, to also get a supporting opinion. But, there could be another court of appeals who has a differing opinion, but I doubt it very seriously. Okay. So here they go with plain meaning, the everyday meaning. We all know when you start walking up the steps of a courthouse, you're walking into the courthouse. Okay. Even if you're in the lobby, you're in the courthouse. Okay. What building is that? That's the courthouse. There may be 89 courts in there, but that's the courthouse. So as you see, failed argument right off the bone. Would never have gone there myself. Waste of time, but somebody collected some money. So, here they breaking it all down, tell us what premises are, which they brought in these deputies, photographs, signage, they just, here's all the stuff that's up there. It's posted. And this is I could sit here and read this, and it's like just a bunch of legal mumbo jumbo and all just right over your head. Here's they're talking about Judge Neal testifying, even though he recused himself, but he's still a party to the matter because he's the one who gave the direct order her not to have a handgun, turn them all in. And what does she do? Turn right around with the handgun and go bail right into court and bail right out. So did not do a good thing, Bonnie, according to the record. Say, you may have a different story. Standard review of sufficiency. Yeah, this is just getting all into the legal mumbo jumbo. Rex Davis. There you go. Okay. So I want to go through that one. But wait, there's more. Mm-hmm. Did you think that's all I was going to bring to the game? Let's monster. Oh, now this one. I just want to show you guys this. I ran into this, going digging through all her shit. And this case right here, 2015, it's a companion case to that, which I have no idea what those are. I haven't even looked them up. I just ran across this. Here's defendant, pro se, state of Texas, evading arrest, detention, class A misdemeanor. And I'm not trying to beat Bonnie up by any means. Don't take that. Is that what this is? The reason I bring this up is because and it's been a minute since I actually read I don't think of the name of it. There's a name for a book that has all these policies in it. Come to me. Anyway, um, like if you have an escape charge, um, even jumping bond, when you go to prison, TDCJ, Texas prison, I know for a fact if you have an escape or an attempted escape, you go to medium custody for 10 years. Yeah. Is it 10 years? 5 years. It's something ridiculous like that, like 5 years. Yeah. So that's not something you want to do. It could be 10. I don't remember. God, it's been so long. I try to forget all that crap. But anyway, that may be something that they look at because state classification, when they're reviewing the file that they receive from, whatever government you're coming from, whatever jurisdiction, they will, just like, you know, y'all guys don't know this. Okay. But when you get convicted, you're going to prison. There's a district attorney, an assistant district attorney, deputy district attorney, whomever, that writes a synopsis of your entire offense, trial, or legal proceedings up to the point where, now you're in sheriff's custody going to TDCJ. And they write whatever they want in there and they twist the truth. If there was no finding of a deadly weapon in the actual trial per se, they'll write it in there that you did exhibit a deadly weapon. May not have been you, but you exhibited it, even though there was no finding. So now, when you get to prison, just because of that statement that was erroneous, they're going to treat you as a 3G aggravated offender. You used or exhibited a deadly weapon. Absolutely. Yeah, that's what happened. So anyway, I hope y'all got this info down here. Y'all want to write Bonnie by now? Poor Bonnie. I feel sorry for her. Got a nickel and doing a dime. Man, talk about working twice as hard. No pun intended. All right. So we got over here to some other stuff. Let's touch down. We went to that one. And we do that. And we went to that. Because I was going through Xfinity stuff. I had everything pulled up on this other laptop because I've been going through. We had a internet outage, cable outage over here in my area 4 days ago, and it's been kicking my everything. Like right now, I'm waiting for this to load. There. Amos here. Sorry, kids. Or sorry, folks. Wonder why only one is popping up. It's odd. Hmm, really? Select your state. Texas. Didn't get closer. Really? That's crazy. Opinions, judges. This isn't how I found them. I found them a different. That's just weird. That one. That's the denials. This one. This doggy. What was it? Brian. Her maiden name. Henry. It's 2011. May have some problems for a minute. 2011, 2015, 2016. Ooh. What number of warrior? 774, 774, 7704, 6. Yeah, more. Yes. Man. Told you. As long as she can afford these attorneys, she's going to be okay. Now, this is in the Court of Appeals in the 7th District of Texas at Amarillo. And this is Bonnie Allen Thomas, aka Bonnie Allen Pieroni. Macaroni. Here we go. Just so you all know, I don't just make this shit up as I walk along the street. So here we go. As I told you, there you go. Amarillo by morning. On appeal from the 18th District Court, Johnson County, trial court number 5926. Here we go. This is 2020, November 2020. So, what did I tell you guys it happened in July 2020? Y'all remember? Pay attention. Appellant Bonnie Allen Thomas. Get this in here. All right. Filed notice of appeal from the 10th Court of Appeals mandate affirming her conviction. She did what? She appealed the 10th mandate. Appeal the mandate. Oh my God. Hey Bonnie, can I be your counsel girl? Your attorney, in fact? Uh wow, guys are just taking your money. You must have had to beg them to do this. Whew, okay. Sorry. I told you guys I hadn't read this. Here we go. Let me reread that last sentence. Appellant Bonnie Allen Thomas filed a notice of appeal from the 10th Court of Appeals mandate affirming her conviction. We dismissed the purported appeal for want of jurisdiction. Accordingly, in 2017, appellant was convicted of carrying a weapon in a prohibited place and sentenced to 5 years confinement, suspended in favor of community supervision. The 10th Court affirmed her conviction in Thomas versus State number 1017 138 CR. All right, let me show you how this reads here. Okay. This is not memorandum opinion, not designated for publication. So that's case is not published, but that's the citing right here. Actually, it'd be all about and then it would be whatever the case style is. And the Court of Criminal Appeals refused her petition for discretionary review, her PDR. Okay, so they refused the PDR. What do you do after that, girl? What do you do? What do you do? What do you do? Oh no, you don't know what to do. See, you didn't delay all that time. You're in a hurry. You wanted to get that P because you thought you were going to get relief, but you brought some busted up issues, and now you walk away with some crooked teeth because you got your brains beat in. Uh, See, after you do that petition for discretionary review, you can do motion for rehearing, motion for en banc rehearing, and then there's the old writ of certiorari to the United States Supreme Court. Or you can hit the Texas Supreme Court and then go hit the United States Supreme Court, and you can delay, just like I explained in the last videos. So on July 13th, 2020, almost 3 years ago, the 10th Court issued its mandate affirming the trial court's judgment. That means, okay, that she had ceased in prosecuting her appeal. And by doing such, the court issued the mandate, making it a quote, final judgment, unquote. That stuck. Okay. Thereafter, appellant filed a notice of appeal stating that the justices at the 10th Court of Appeals have not followed the Constitution. Their decision rendered 7/13/20 is void. That appeal was later transferred to this court by the Texas Supreme Court pursuant to its docket equalization efforts, government code. It's because some of these courts of appeals are in very small jurisdictions, especially the ones up in the Panhandle, the very northern border up by the Red River, and definitely out in West Texas. So, you know, uh, Eastland gets thrown a lot of bones, Amarillo, Waco. Yeah, I've been to all those courts. We have jurisdiction to consider an appeal from a judgment of conviction or where appellate jurisdiction has been expressly granted by law. Here's going over just legal mandate mumbo jumbo. Accordingly, we dismiss the appeal for want of jurisdiction for occurring, do not publish. That's a no-brainer right there. Let's see this other one. This one on the recusal. Try and transfer it to another court. It must be one of these. I just start opening stuff. Yeah. On May 26th, 2021, 2 years ago, right? Clearly, almost a year after she met DLS, the call, I'm reading it right here, call from Relator, which she's filed a ex parte, stating that an affidavit of inability to pay court costs will be mailed today. Relator stated she needs immediate and permanent relief. And somebody filed a petition for writ of habeas corpus. Denied. Imagine that. So where was that? Oh, uh, there was just some stuff. Oh, yeah, it must be this one. Found a default judgment against her credit card company or something. Yeah, defend herself on that one. This one. Man, I went through so many of these. She's just got a ton of stuff. Here's a memorandum of opinion, relators petition for writ of mandamus, petition for writ of prohibition, and request for emergency leave filed on March 13th, 2017 are denied. Chief Justice Gray dealt with him too. I get the case transferred. They know her pretty well over there in that area, apparently. Yeah, she's trying to transfer the case over to Austin, and they're not trying to hear it. Yeah, I mean, she's getting swatted down left and right. Same stuff. Memorandum opinion, one pager. Petitioner's emergency application for extraordinary writ of habeas corpus is denied. May 21st, 2021. CV, same one. Same ones, just different headings or stuff. Where that one takes me. Oh, yeah. Now I remember it. Oh, all right. Back to your Joe Day, Joe Day, Joe Day. Oh, I need the. I have a moment. Really? Okay. Uh, some of these are really good in here. uh, I'd like to go through each and every one of these and read them. Let's see. I mean, here's South Carolina. That's a traffic ticket. And there's some Florida stuff. It's writ habeas corpus. And this is the case I was telling you about, Bank of America, where she lost fault judgment. It's out of Collin County. Wisconsin. There's that federal case that I was reading. I was like, yeah. Yeah, we're getting a little out of. Which one is this one? Texas Supreme Court in Bonnie. That one. Yeah, that's a different one. Oh, I have a brand new one. This is an old one. Do that. This is back when she had some money. She could pay for those attorneys. Or she had money, or has money and don't want to pay for attorneys. So, oh, these is okay. Damn, getting amicus letters in a divorce case. Wow. Yeah, this turned out to all out war. I can see that. All right, so There's another Texas Supreme Court I'm looking for, apparently. I told you, this woman busy in these courts. Henry, there we go. Habeas corpus. Yeah, here we go. 21. That means I was filed in 2021, 440 case. Petition for writ habeas corpus Henry Bonnie Allen Thomas. Here's the petition. Here's a PDF. So let's see the quality work here. What? I thought we were going to see some quality work. This is from the desk of Bonnie Allen Thomas in the Cleburne County Jail. And she's writing the trustee, Nathan Heck. That would be the CEO of the Judiciary Courts in the state of Texas. I'm filing this writ with the Texas Supreme Court because the 10th Court of Appeals has failed to rule timely on application for emergency writ habeas corpus filed by my power of attorney May 5th, 2021. That would be after she met DLS. The 10th Court's failure to rule is causing an unconstitutional confinement to continue. This is a miscarriage of justice. I demand relief right away. Please have your magistrates rule right away and render relief and release from void judgment and confinement. God bless you. God bless Texas. Bonnie Allen Thomas, beneficiary and sole heir of Bonnie Allen Thomas. Huh. Are you starting to see a change in the verbiage? What's being filed, how it's being filed, the representation, emergency writ of habeas corpus. In re Bonnie Allen Thomas, and you can see the lowercase letters at the beginning. She almost slipped up, made that a capital. Out of habit. Same thing with the T. Now comes Bonnie Allen Thomas. I am a living Texian American national woman. I'm not making fun of you, okay? Because we've all done this silly stuff. But this ain't gonna work in the courts. It ain't gonna work in Texas courts. And if you continue to do this, girl, you're gonna find yourself in administrative segregation, locked up, and sequestered from everybody else because you said the magic word, UCC. Be careful. Take it from Fearless Floyd. You don't want the Secret Service, the FBI, the IRS, and the U.S. Postal Inspector come knocking on your cell door, do you? You better ask somebody, Bonnie. All right. I bring this writ of habeas corpus as a writ of right under the United States Constitution, Article 1, Section 9, Clause 2, and Article 1, Section 12 of the Texas Constitution, which they wholeheartedly ignore in Texas. Like it doesn't even exist. They probably would value a roll of toilet paper more if they had a choice in the back stall of a men's bathroom. Constitution, I'm choosing the toilet paper. Thank you very much. That paper looks a little old and rough. Just saying. This issue concerns multiple violations of international treaty between Texas and the United States of America. Texas joined the Union of States by treaty contract December 29, 1845. Facts. I demand Article 3 court. Those are facts. A demand is a fact. Okay. All right, Bonnie, we'll roll with that. This writ shows a pattern and practice of unconstitutional error and a severe, unending abuse of power to harm me without legal authority or jurisdiction. I am presently confined against my consent in the Johnson County Jail for exercising my fundamental liberty interest to live in my house on my own land. This is a trespass on my God-given rights. Section 1. On September 22nd, 2020, I was served with a citation of divorce and a temporary restraining order drafted by Christopher Charles Cook and the order signed by Magistrate Sidney Beasley Hewlett on September 21st, 2020. Page 1 of 10 gave me no notice of the TRO hearing held on September 21st, 2020. The document signed at 4:50 p.m. said the court examined the pleadings and affidavit of petitioner and 5 petitioners entitled to a temporary restraining order. This statement of fact is false. There was no affidavit as required by Texas Rules of Civil Procedures, Rule 680, 683, and no bond was applied for or gained to protect me from injury or error of the TRO. The bond was mandatorily required by Texas Rules of Civil Procedure 684. The tactically drafted restraining order restraining me from my home and land and all my tangible belongings within my home. All the furnishings within my home were previously awarded to me in a previous final court judgment in Collin County, Texas, September 11th, 2009, res judicata and collateral estoppel. She did finish collateral. Applied to this final judgment. No E in judgment. Originated from a private contract protected by Article 1, Section 10 and Article 1, Section 16 and Article 1, Section 29 of the Texas Bill of Rights. My home furnishings are not community property nor owned by the state of Texas, but solely and exclusively owned by me. My home and my rental home were purchased with aired assets and assets awarded me from the September 11th, 2001 judgment. Or 9 rather. It is an abuse of discretion and trespass against me when Magistrate Hewlett did not strictly follow the TRO statute while in her clerical capacity. Rules of Civil Procedure 680 through 683 is preempted by higher law, United States Code or United States Constitution, Fifth Amendment, and the Texas Constitution, Article 1, Section 19, I believe that is, which is protected by the Supremacy Clause of Article 6, Section 2. Christopher Charles Cook drafted a broadly written TRO to enjoin me from my separately and privately owned home, land, furnishings, rental home, and rental income, which Lloyd Griffith Thomas conveyed fraudulently in his corporation name without my consent 3 weeks prior to filing for divorce. Lloyd Griffith Thomas planned in advance to steal everything I own, and he hired Christopher Charles Cook to help him with his plan to seize and steal everything I own. Christopher Charles Cook knew he could gain financially by encouraging Magistrate Hewitt to sign a TRO order shifting 90% of all assets to Lloyd Griffith Thomas, thus creating a large legal war between spouses. This act of barbarity is forbidden. The preliminary injunction, disguised as a TRO, lacked an affidavit swearing an irreparable injury looming over him and failed to apply for a bond. The restraining order can be rendered to stop injurious or illegal behavior, but cannot enjoin a living woman from exercising her God-given rights to her land, home, assets, rental property, and rental income. Theft is forbidden by God. See Exodus 20, chapter 20, section 15. Thou shalt not steal. I am, as a woman, entitled to equal protections against trespassing my rights. See Texas Constitution, Article 1, Sections 3 and 3A on September 11th, 2020. I was given no opportunity to be heard. Another hearing on October 1st, 2020. Again, I was given no opportunity to be heard, nor could I cross-examine adverse witness Lloyd Griffith Thomas. This act by Sidney Beasley Hewlett denied my rights to due process under United States Constitution, Fifth Amendment, and Texas Constitution, Article 1, Section 19. I realize the TRO was void because violations of due process, Article 1, Section 29 says it is withheld from all powers of government and all laws contrary to Texas Bill of Rights are void and unenforceable. I have corrected my status per declaration of status filed in the Public Records Superior Court of Lamar County, Georgia. See book number. Blah, blah, blah. I am not a 14th Amendment citizen. All rights and immunities guaranteed in the U.S. and Texas Bill of Rights protect me by treaty law. Section 3. Man, we got a lot more to go. Y'all want to keep going on this? Because I sure don't. I'm already tired of reading. And they shot this down. Confinement of 15 days of solitary isolation without justified legal reason is misuse of taxpayer funds and a misuse of real property, a misuse of jail service staff, and fungible tangible property, confinement of I live and by for. Oh God, really, girl? Oh no. Now you're. Oh, really? Hold on. Uh, Magistrate Hewlett had not signed any written order yet, but gun carrying deputies jumped on me in the courtroom, twisted my arms behind my back. I cried out, I do not consent, and was bound in shackles and chains and kidnapped and driven to the Johnson County Jail. I was confined in against my consent in solitary confinement for 15 days. I was not sick nor violent. Solitary confinement is known to cause brain damage. It's cruel and unusual treatment, which is trespass against my God-given rights. Oh, come on, Bonnie. You should have used that 15 days as an opportunity to reflect, girl. That's when you get down and you really do your hard thinking, okay, and your planning and your strategy. You have all that peace and quiet, and you're not around anybody. Okay. You missed your opportunity. No surprise. Special appearance. Okay. All these dog whistle words thrown out there. You know, I use them too, but on April 29th, 2021, I was facing 49 accusations of constructive criminal contempt, which could result in 66 years, 6 months of confinement, a life sentence for simply living in my home and land. I was entitled to a trial by jury. My jury fee was paid October 2020 and jury demand filed. I was entitled to a unbiased tribunal pursuant to the Sixth Amendment, trial by jury, the Seventh Amendment, Texas Bill of Rights, blah, blah, blah. Denied. Person testified. I had a lot of time. This would probably be interesting. Get a witness. Here's our order of the court. And that's it. And what they do? Memorandum opinion. Petitioner's emergency application extraordinary written charges denied. We're not going to waste our breath. But what you don't see is a what? Is a what? Is a what? You see a story. Okay, let's go to the beginning. Come on. Dear Nathan Heck, emergency writ of habeas corpus. Okay, so here's the title. Now, let's go see what she wants. Sure is doing a lot of bitching, a lot of complaining. Wah, 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 wah. Oh, she don't want anything. Okay, denied. Yeah, I can't make this up, kids. Look, y'all think I'm bullshit. Y'all think I'm bullshit. Y'all think I'm just sitting here making all this up, aren't you? Watching me read. There it is. You filed a silver coin. Look at that, folks. Plus Federal Reserve notes for the jury fee. She gave pure silver. tell that had a big effect on the whole proceeding, right? Here's what I just read. Magistrate Hewitt had not signed any written order, but gun carrying deputies, they took me off to jail. Gets my consent. I do not consent. Still whining. Wah, wah, wah. I appeared by special appearance for exclusive reservation all my God-given rights to settle the matter that day. I have an equitable right guaranteed by the 9th, 10th United States Constitutional Amendment. USC stands for United States Codes, girl. To close the accused and settle the matter. I tried multiple times and was denied each time. Sounded to me like you went in as belligerent, infant terrible, and argued and debated the whole time. And become a combative, and they did what they do is they take you out. So it looks like to me now you're whining about it, and you just asked for emergency relief, and you didn't even tell them what the hell you wanted. I want out of prison. Why? Why was it unconstitutional? Why should I get relief? Huh? Come on, man. Dang. You can go back to the law library. Well, if you're in Texas prisons, you're going to have a hard time litigating simply because they've gutted it. It's virtually impossible without prior knowledge or extra books that you've ordered and had sent in from the world. We call them shortcut books, like these O'Connors. They're shortcut books. That Georgetown Law Journal, shortcut book. Because they don't have books anymore in the law libraries. They do, but they're not updated with updated pocket parts. And when new books come in, they don't get new books. If you want a case, you have to order the case, and they give you like a printout. They print it out like on your computer, and here you go, stay together. Here's your case, sir. Yeah, and you can only order 3 a day, and you don't get them that day. You get them the next day. Yeah, I know. And if they're all 3 of them are misses, well, 2 hours are screwed off. I know. Like I said, it's almost virtually impossible. They have it that way for a reason. They want you to go up against $1 billion law firm. And I know for a fact now, twice, that $1 billion law firm didn't have qualified attorneys to go up against me and went out and hired free world attorneys. And I find that astonishing. I mean, on par with what I was doing legally, yeah, I would expect it, but to actually realize it, and yeah, that's remarkable. I had no idea. So, I hate to brag on myself or anything like that, but no, it's they were terrified of me. They didn't know what the hell to do with me. I was way too smart, throwing way too many things at them that they had never seen before, that nobody was throwing at. And I was throwing hard fastballs, man, right at the chin. They weren't like it. So poor Bonnie over in Hobby Unit, Marlin, Texas. We've just gone through some of your stuff. See what this one is. These are all your cards from the court showing that things were filed. Another postcard. Call from the relator, or Bonnie, regarding status of case. Relator stated that she is sustaining a daily injury each day that the court does not rule on her. That was June of 2021. Wonder what she's going to throw at him now. What she's got left. So, And Miss Thomas. $155 filing fee. Hey, Blake. All right. Well, there you go. That's part 3 of the saga of Bonnie, Ruth, Allen, Thomas, Griffith, Pieroni, Straight. Starting to sound like Animal Rights, right? Oh man. So anyway, you guys write Bonnie, tell her Fearless Floyd said hello, sends his best, and um sit down and shut up, get out on parole, and hook up with some real people who do some real things. It won't get you in no trouble. That's about all I got for you. Bonnie, 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 Bonnie. So tomorrow, maybe tomorrow. Might do it Tuesday. I don't know. We'll see. Uh, got a gig in Galveston tomorrow. Got to go build a video wall on the bank. Um, so be doing that, and then I'm off Tuesday. I'll be down there probably fishing, riding my bike. Wednesday we're doing the out, which is real quick. So um, don't know when I'll do part 4. Don't know if I'll post it, do it tomorrow and post it later or whenever. But anyway, part 4 is coming up. And in part 4, to give you a synopsis, what we've seen so far, you've seen a little bit of the influx here, at the tail end of this, with David Straight coming in. Anything past July 2020, David Straight, you can start seeing the influence. But you're really going to see it from July 2020 up to the present day, in her district clerk record in Johnson County in that F50926 case. Quick. So if you like the video, like, subscribe, share, hit that notification bell, leave a comment below. As always, the show is hosted by my sponsor, and I want to thank my sponsor for sponsoring the show. Appreciate everything everybody does for me and the show. It is Mortgage Audits Online with Sean Adley. And hit him up, mortgageauditsonline.com. You've had a mortgage, auto, credit card, personal loan, or any type of financial transaction where you got a loan, traded a piece of paper for some money, your signature basically. 95% chance Sean's going to find some fraud in that financial transaction. He will do a forensic audit. He will gather that evidence. He will turn that evidence over to you after you retain him as a client. And it's up to you to determine whatever you want to do with that information. You can take it to arbitration. You can settle out of court, take it to court, circuit court, whatever. Choice is yours. If you're going to do anything financially, like buy a house, get a car, get a new credit card, whatever, go read Sean's website, mortgageauditsonline.com. Tons of free information. If you want even some more better information, code Fearless. When you go to the website, mortgageauditsonline.com, the little message box, send Sean a message, put code Fearless in there. He's going to send you a free $295 free info kit. And I'm telling you, if you just go read his website with that information, that's just awesome information. For free. Tells you a lot. I can't even imagine, how much better you're going to feel after you get the free info kit and do decide to move forward with Sean and his services. So I want to thank you, Sean, for being our sponsor. Go check him out, mortgageauditsonline.com, code Fearless, free $295 information kit. As you can see on each side of my big ass head, I have the Trust 101 class. That is just a fundamental class for beginners who have never set up a trust before, or who had one set up for them 10 years ago and it's been sitting in a safe on a shelf or in drawers or places other than the file in which it belonged. I like doing that. Quoting Jay Carahan. Anyway, that class is available right here. 24/7 all access. Learn at your own pace. Watch the videos whenever you want. Materials all there. Every page that you need to create your trust, get it up, operational, get your EIN, get your non-interest-bearing bank account, all there, right there. Well, over here, well, right there, right there. Yeah, that thing. Nope, that thing. I get it right sometimes. Anyway, 50-50 shot every time. Okay, so anyway, that's our trust class. That's our trust class. That's our trust class right there. You want to take all our classes right there. Hey, I got that one right. $5.99. That's a 101, 201, 301, 401, and the VCR class. 5 classes for $5.99. And again, those are 24/7 all access. So what that looks like is basically the materials are in the files in a private Telegram group that I will allow you to go into and mingle with all the other students who will mentor you and assist you with whatever class you are in. So if you're in the 201, y'all want to talk about deeds and all that, there you go. That's in there for you. Y'all should be building a massive database of all types of deeds. I don't play in the rooms. I build these rooms for you guys. They're y'all's. I make, if you want to be an administrator, boom, I'll make you administrator like that and you can run it. I'm not tripping. It's yours. I made it for you guys. So if you want to get the classes, there you go. fearlessfloydshow.com/store. Boom. Everything's there. I am on Telegram. For some reason, a lot of people don't know I'm on Telegram. I'm on Facebook, Unified, Twitch, Odyssey, Rumble, BitChute, Twitter. Did I miss any? I know there's a bunch of them out there, and I'm probably on all of them. So you can't miss me. Easy to find me. Fearless Floyd Show at yahoo.com. Email me. Big things happening with Khalifah County. Big things. I'm fixing to do another video on that. I was going to do it tonight, but I'll give y'all a sneak peek. Okay, so I got a video coming. So if you watch this all the way to the end, you're going to see it. But if you don't, you won't. And if you don't, and it won't matter. And sneak peek. June 17th, 2023, affidavit of publication. Ooh, this notary public guy right here. Uh-oh. He put it out there. What is that? County of Califia, California. Attention Tiggle, California Judicial Assembly. Affidavit publication of public notice. County of Califia, California. USA. All right, okay, folks. Here it is. I, Tarvin Floyd Pleasant IV, Commission Notary Public for the state of Texas under the laws of the state of Texas. And guess what? If you want to see the rest, you got to watch the video. But there's a little teaser. Thanks, kids, for watching. Like, subscribe, share, hit that notification bell. And we'll see you for part 4 with the straight facts on Bonnie Straight. And this is where it's going to get nice and juicy. So stick around. There's tons of stuff to cover. And when you start seeing it, you'll be like, oh, boy. Love you.